Well, Ruth Bader Ginsburg, as the head of the ACLU Women's Rights Division, worked through tactically and strategically how to try to advance women's rights issue. And so we have a short little tiny cartoon here.
People who want to keep women down would like nothing better than for women to go off in a corner and speak only to women. Nothing would happen. You need to persuade men that this is right for society.
Psst. So you want to know how RBG convinced those 9 men to give equal rights to women? She didn't just bring cases where women were being discriminated against. She supported cases where men were the victims.
Oklahoma had a very silly law. Girls could buy 3.2 beer at age 18, but the boys had to wait until age 21.
Raise your glasses and shout loud and clear, more beer.
So she essentially told the court, listen, these boys should have their beer, same as girls.
Yeah.
And so discrimination like this, based on gender, it's bad for everyone, right?
Yeah.
Aha! Finally, after hundreds of years of women fighting for equal rights under the law, a breakthrough with a case about boys and beer.
We wish that the court had picked a less frothy case to make that announcement. But of course, we were very, very pleased.
And shout loud and clear, more beer.
Obviously, we've got a lot more work to do.
So Ruth Bader Ginsburg twigged on to the fact that these justices, the men on the United States Supreme Court, had basically never met an example of discrimination against women that they didn't like, that couldn't be justified. They were applying what was called essentially a rational basis test. Is there any reason why a state might say women can't do these things? If Illinois says women can't be lawyers, well, maybe Illinois has a good reason for that. Maybe it's because, women, just the courthouses are rough and tumble places. They probably know what they're doing. There was a case even in the 1950s, I think called Cosert, in which a woman fought a law that said that she couldn't work in a bar. And the United States Supreme Court considered this and said, well, bars are rough places. The statute said that a woman could work in a bar if it was owned by her husband, or her brother, a family member. But other than that, they were not allowed to work in bars. And the Supreme Court, as late as the 1950s, said that seemed just fine to them because no doubt the state legislature had women's best interests in mind. When we look at the 14th Amendment says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor deny to any person within its jurisdiction equal protection of the laws. Well, that was from 1868, but obviously it was not construed as applying to women. One of the very first cases in which the United States Supreme Court applied this to women was in 1971. In 1971, with the ERA in process, Vietnam, women's rights groups, just think what America was like in 1971. There was a case called Reed v. Reed, and it was a very sad case. A young man, I think a teenager, maybe had committed suicide. And he had lived with his mother, I think didn't really have any particular contact with his father. But there was a state law that said that we're going to prefer relatives to non-relatives and prefer males to females. And so the father sought the right to be the executor and the court replaced mother as executor of the boy's estate, and the mother appealed, and the United States Supreme Court said, we don't see that there is any reason for this law. Now, they didn't necessarily say this is a violation of the 14th Amendment, and they didn't say we're going to hold this to a heightened scrutiny. They just said, that doesn't seem right. That was in 1971. In 1972, there was a Tulsa lawyer named Fred Gilbert, and he won a case in the 10th Circuit Court of Appeals. If you're familiar with the structure of American courts, we have state courts and we have federal courts. He had fought a case in the federal court and had lost the federal district court in Oklahoma. And then he appealed that to the 10th Circuit Court of Appeals, which is just below the United States Supreme Court. And that case was a case of Lamb v. Brown. And that was referring to a provision in Oklahoma law that said the term child in Oklahoma means any male person under the age of 16 years and any female person under the age of 18 years. And that was used to convict, say, 16, 17-year-old boys of crimes, whereas a 16 or 17-year-old woman was charged as a juvenile. And once again, that was a matter of discrimination against men. And Fred went and challenged that. Now, Fred was a graduate of Harvard Law School, and I've heard many people say that Fred never seemed to have any other tie except his Harvard tie. He always wore his Harvard tie wherever he went. That was his thing. Fred was a member of the patent bar. He was brilliant, but he never wrote any patents. He was not particularly interested in that. Fred loved the Constitution, and Fred started doing criminal appeals. And so, some 17-year-old kid, I think Lamb, said, hey, is this right? My girlfriend and I, we commit a crime together. We're both 17. I'm charged as an adult. She's charged as a juvenile. This went back to Oklahoma territorial law from 1890. In 1890, Oklahoma had set up this distinction between men and women and the age of majority. The exception on that young men were adults at 16, except for the purpose of buying beer. For buying beer, they had to be 21. And women reached the age of majority at 18 and could buy beer at 18. So Fred won this huge victory in the Oklahoma, not in the Oklahoma court, but in the 10th Circuit Court of Appeals on Brown v. Lamb, or Lamb v. Brown. I don't remember which way it goes. Lamb v. Brown. And the court said, oh, no. That's absolutely unacceptable. You can't have different criminal charges for people. It helped that there's a lot of scrutiny that goes in when it's a crime, when people are going to go to prison, so when the young man goes to prison, but the young woman just gets counseling and juvenile and gets to go back to the house. And they said, that's not right. That's not fair. That's wrong. Well, in the meantime, in Stillwater, Oklahoma, there was a young man named Mark Walker. And Mark Walker was the president of of Lambda Chi Alpha. And he was also taking political science, and they were talking about the laws. And he mentioned this rule that that 18-year-old girls could buy beer, but young men couldn't, and that this didn't seem fair. And the political science professor said, well, what are you going to do about it? Well, he went to the Oklahoma legislature and he tried to push for change, but that was unsuccessful. So Fred Gilbert was coming off of this big win on gender discrimination. Mark Walker approached Fred and said, what do you think about this? Well, Fred, never saw a fight that he didn't want to go fight. And he said, absolutely. Fred jumped into that case. Fred said to Mark, well, now, Mark, we probably need a vendor too, not just you, but let's find a store. So Mark Walker went around to the different stores in town, and he said that he would, try to buy some beer. And often if they'd start to sell to him, he'd say, well, now, wait a second. I'm only 18. Are you gonna still sell this to me? And they'd say, oh, no, sorry, we can't. That would be illegal. And he says, well, how do you feel about that? Most of the places said, we don't care. Well, then he went to a little convenience store, a little drive-through convenience store called the Honk and Holler. And it was owned by a lady named Carolyn Whitener and her husband. Now, he went in and he saw that Carolyn's name was on the liquor license. And the reason for that was that her husband had lost his license to sell liquor because a young soldier had come in. We could send 18-year-old men off to Vietnam. We could give them guns and send them off to war, to kill, to fight, to die. But then when this soldier came back to Stillwater and wanted to buy beer, he was supposed to be told, no, I'm sorry, you're too immature for a beer. You can't have a beer, it's against the law. Well, her husband went ahead and sold the young man a beer, and somehow the forces that be caught him. I have been informed that the young man in question was not part of a sting. He didn't do this deliberately to the owner because that would just be nasty. But Carolyn was very much aware of this. And Carolyn said, I think it's wrong. I think that a young man comes in here and he's in uniform, he's a soldier. She talked about how you could just tell the difference between the soldiers and the way they carried themselves. And she thought it was outrageous that an 18-year-old girl, no matter what she was like, no matter how frivolous, no matter how silly or foolish or whatever, that she could buy beer, but that 19, 20-year-old young man could not. And she gave Mark Walker an earful and she said, I think it's wrong. And he said, well, I'm working on a paper for political science. Can I use you as a source? And she said, sure. Now, there's some debate about what actually happened here. And people that know Fred Gilbert say this is entirely possible. But the next thing she knows, it's in the news. Her husband calls and says, what the hey have you done? And she's like, what? And he says, well, apparently you've sued the governor, and everybody. She said, we sued everybody but the dog catcher. And she said she had no idea that she was being named as a plaintiff in this suit. And, and did Fred Gilbert really go and throw this woman in and forget to have a conversation with her about that? It's possible. We don't know. But at any rate, so Carolyn Whitener, the owner of the Honk and Holler, became the other plaintiff in a lawsuit to overturn this Oklahoma law because it was discriminatory against men. And they filed that in the federal court. And Fred Gilbert took the case up. He was not paid a dime. Nobody had any money to pay Fred, but Fred would just sail into the fight. Anyway, he took it all the way to the United States Supreme Court and just did it pro bono because that's the kind of guy he was. So they fought in the district court and lost on this issue of gender discrimination. And, and Fred's kind of licking his wounds. Well, then Ruth Bader Ginsburg comes along and She's over there at the ACLU and she sees the decision on this case, and she basically contacts Fred and says, "Hey, Fred, um, I think you should appeal that to the United States Supreme Court." And he says, "Oh, I don't know. I don't think they'll do anything." And she says, "Come on, we'll support you. My group at the ACLU will write an amicus brief. I'll do it with you." And so apparently, it was Fred's case. Fred took it forward, but he worked pretty closely with Ruth Bader Ginsburg. Now, she called him Ranger Fred. Fred was in the United States Army Special Ops, Special Services, and he was an Army Ranger. And this formed a huge part of what he was. And Fred was, according to his later client, Curtis Craig, he was a self-avowed male chauvinist pig, he said. And he had little, if any, interest in women's rights, the women's libers, the ERA. None of that really meant anything to him. He just thought that, 16-year-old boys shouldn't be charged as adults, while 16-year-old girls were juveniles. And he thought that it was wrong that a 20-year-old Vietnam vet comes back and can't buy a beer, but an 18-year-old girl can. And so he was genuinely interested and concerned in the ways that these laws were impacting men. Now, Ruth Bader Ginsburg, she realized that gender discrimination is gender discrimination. And even those things that appear to be protecting women are just the flip side of oppression, just another way of holding them down. And a lot of times they would say, why would you do this? Why are you doing this thing that might work to the detriment of women when they should be protected? A classic example of that is, women can't be in combat in the Army. But that translates to women can't advance. A woman could never be a 4-star general. A woman could never progress through because combat training, combat experience wasn't a prerequisite for advancement. So that was something that supposedly protects women, but in reality was keeping them down. And so apparently RBG would work with Fred, as she had to really try to get him to frame the issues in a way that she could work with, that this is gender discrimination. Now, she said that, her assistant one day was, just typing up all these things, sex discrimination this and sex discrimination that, and her assistant stopped and said, Ms. Ginsburg, we just keep saying sex, 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 sex. And you know what those men think when you say sex. And they're not thinking what you want them to think. And so the woman said, why don't you come up with another word? Use a grammar word like gender. And so that's when RGB started saying gender discrimination. At any rate, so Mark Walker and Carolyn Whitener were the plaintiffs. Now, the problem was, as this thing progressed, Mark Walker was going to turn 21. And so that would mean he would be aged out. The case would become moot as to him. Because once he's 21, he could go buy beer. He doesn't need relief. And just the general concept, well, it's still not fair. It's still wrong. Courts don't really care about that. The court would say, sorry, you're 21. This is not a problem for you anymore. The case is moot. Go away. And so the district court allowed them to substitute in another 18-year-old. So Mark Walker went back to his fraternity, and he got a young pre-law student named Curtis Craig. And Curtis Craig and he had both been, at Moore High School. They had both been on the wrestling team. This frat house sounds like it was, I don't know if Animal House was based on it, but it sounds as if it might have been that these wrestlers would go running through the halls and tackle each other and fling each other into walls. And there were dents and holes in the walls. And it was a pretty rowdy group because a lot of them were wrestlers. But this was a fairly serious issue. I mean, in a way, yes, they wanted the ability to buy beer. But, Mr. Walker, as a political science major interested, he was interested in the justice issue as well. And then Curtis Craig was pre-law, and he would go on and become a lawyer and practice here in Tulsa. So they got Curtis Craig to substitute in, and he was young, and it goes along. Then they're all set to argue in front of the United States Supreme Court. At the time, there was a federal law that said the United States Supreme Court had to accept any appeal challenging the constitutionality of a state statute. That law was changed in 1976. But at the time, if you were challenging any state statute on the basis of constitutionality, you could go first to the federal district court and then straight to the Supreme Court. You didn't have to mess with any courts of appeals, and you didn't have to try to win certiorari. The United States Supreme Court only accepts about 1% of all the cases that are filed in front of it. In fact, I think it's less than that. At any rate, they were set to argue in I think it was 1976. They were set to argue in May on the May oral argument term. But then they got bumped. They got bumped to the October 5th day. And that would be fine, except Curtis Craig turned 21 in September. And so the first, 10 minutes or so of oral argument are taken up with the court saying, well, now, isn't your young man 21? And isn't this moot now? And Fred is saying, this is an issue basically that evades review. It's an unconstitutional statute. It unconstitutionally applies to men instead of women. It gives women, an advantage. And, but our plaintiffs keep aging out. They tried to substitute in the Supreme Court, but they were denied the right to do that. The Supreme Court said, well, we think it's moot. But Fred hung in there, and Ruth Bader Ginsburg was sitting at counsel table with him. She had filed an amicus brief on behalf of the ACLU. She was present at counsel table. They decided that she would not argue because at the time, I think she was a little bit reluctant to have it seen as a women's issue. These are the women's livers coming for you. But she wanted it seen as an injustice to men, and she was hoping to achieve a test of heightened scrutiny, to get off of the rational basis test that all previous cases had done. Even Reed v. Reed, the one about the mother who said, why does dad get to be the executor of our boy's estate just because he's a man? And there the court's like, well, there's no really rational basis for this. And so even though that case moved us toward equality, it did not hit a heightened standard. Well, Fred hung in there and said, well, Miss Whitener still has standing because her business suffers. They said, does she have standing? She's over 21. She can buy beer. What difference does it make to her? And he said, because it cuts her customer base down. But more than that, as we know, they are also subject to criminal penalties and loss of license if they were to sell to a young man who's 19, but not if they sell to a young woman. And we know that is exactly what happened to her husband. Now, as an aside, when her husband, heard this on the news, he calls it, he says, "What have you done and why have you done it?" And she's like, I guess I'm in this lawsuit. Isn't it cool? He didn't think it was cool at all. He thought it was women's liber crap. He was a very controlling man. And he said, "You get out of that right now. You dismiss that." And she thought about it and she decided she had had enough. And she said, "No, I'm going to stay in and do it." And to her credit, through all the time that it took from when this was filed in 1972 to 1976, when it was finally heard by the United States Supreme Court, the honk and holler was a money-losing business. And she and her husband had purchased a string of other convenience stores around Stillwater. They had a bunch of 7-Elevens. And the 7-Elevens were working, they were great. The honk and holler was, it was a money-losing thing. But she kept it open. She kept it open precisely for this case. She kept it open so that they could stay in the case, so that they could have standing and see it through. And so, kind of like Fred Gilbert, who did this for nothing, she stayed in, hung in there in spite of personal problems with her husband because of it, and in spite of the fact that it meant that they kept open this business that was losing money. When they got to the Supreme Court, I think the justices were, like, well, isn't this kind of silly? It's about beer. Does it really matter? And doesn't the legislature have reasons for this? The young men, they drive more, they drink more, they commit more alcohol-related offenses. And there was a lot of argument about the statistics and what Fred Gilbert was arguing, and with the assistance of RBG, who would be handing him notes. And he would give her credit. He'd say, "Your Honor, my learned counsel, reminds me that there's a case, of this and such." But Fred hung in there and he said, "Yes, it is possible that men, 19-year-old boys drive more than 19-year-old girls. And it's possible that as a result, they are in more accidents. And as a result, they commit more alcohol-related offense." And he says, "But a specific young man versus a specific young woman is no more likely than that young woman to do any particular thing." And he urged the court to apply a standard of heightened scrutiny. They also said, "Now, why didn't you bring this as a class action? Your kid has aged out." Well, that was very expensive. This was not a major legal thing. This was just kind of Fred and some kids. Some kids and the owner of the honk and holler. And there they are in the Supreme Court. And don't get me wrong, Fred Gilbert was brilliant, but they didn't have any financial resources other than those that Ruth Bader Ginsburg could bring to bear, on behalf of the ACLU. In fact, Curtis Craig, I talked to him the other day, and he said that, that he was never able to pay Fred. And he tried. He said he would put big pickle jars in the beers with a sign saying, "Please donate to pay the lawyer who's handling this case." And he said that failed because anybody who had 50 cents would use that 50 cents to buy a beer. And they didn't care about the litigation. Anyway, there was no money to do a class action. The class people would rotate in and out. Now, at this time, at the time that the Oklahoma Supreme Court was hearing this case, it matters that this was in Oklahoma. And it was because as the Equal Rights Amendment was circulating through the states, and I think that ultimately it was approved by 35 states, and it needed 38. Well, Oklahoma was the first state to say no. Oklahoma was the first state to say, no, we don't have any, we're not going to hold with that women's liber stuff. We don't believe in that. And the court, against this backdrop, and this is what Curtis Craig said, he felt that the court, against that backdrop, thought, you know what? Let's pay a little bit of extra attention to this Oklahoma case. This isn't just about beer. And he thought that the court really maybe was looking for a way to start the movement of equality. Now, RGB and Fred Gilbert were certainly an odd couple. I think we all know how brilliant Ruth Bader Ginsburg is and was. And, she had been to Harvard. I think Harvard didn't treat her well. And so she transferred and went to Columbia. She graduated first in her class. Fred Gilbert also went to Harvard. And as I mentioned, he passed the patent bar. And he was just a brilliant mind. But he was one of those eccentrics. So when you'd see him walking down the street, he'd look like a homeless person. He could never get his shirts tucked in. He'd be shuffling down the street. Sometimes he'd be moving his hands. His social skills were appalling. And, one of the partners told me that he was like someone, actually, I think someone told me this tonight, that you could put a brand new suit on him and it would look rumpled and derelict, within 2 minutes. And so RGB is this ardent feminist, and Fred Gilbert was a self-proclaimed, as he said, a male chauvinist pig. He didn't care about these women's rights. This was not his thing. But he and RGB were friends. And the people that saw them work together and knew them said that they were funny. They teased each other. They kidded. And they respected each other. He respected her. She respected him. And years ago, when she came to Tulsa to speak at TU, she and Fred went out to dinner that night. I'm looking for what else. At any rate, the United States Supreme Court did overturn the Oklahoma law and said that they were going to apply a heightened scrutiny. Previously, we really had two levels. We have rational basis. Is there any rational reason at all why a state legislature would say, that men can do this, but women can't, etc.? Any rational reason at all? If we can think of a reason, we don't even have to show that it was really the reason, just that it could have been, then that was enough. And then there's a level called strict scrutiny, where the burden is on the state, and they say, hey, these statutes, these laws, this seems unacceptable. This appears to be discrimination, racial discrimination, whatever, and justify it. Why is this okay? That is strict scrutiny. Well, in this case, the United States Supreme Court went in the middle. It was a heightened scrutiny, and that itself was a huge victory for RGB. And of course, getting the reversal was a huge victory for Fred. The United States Supreme Court held that the Oklahoma law was unconstitutional, and therefore young men could buy beer the same as young women at the age of 18. I should mention that in 1972, Oklahoma had amended the statute following Reed v. Reed to say, and following Fred's big win on the juvenile criminal issue. And so the Oklahoma State Legislature had said, okay, everybody reaches the age of majority at 18, but we're going to still keep this exception about, young men not being able to buy beer, because we just don't want them to be able to buy beer.